Now, advocacy group Alliance for Social Equity and Public Accountability, ASEPA, is the latest to kick against the Apex Court's announcement yesterday that it will deliver judgment on any suit challenging the presidential election within a maximum of 42 days. The group argues peculiarities within a case determine the length of hearing and subsequently the delivery of judgment. Executive Director of ASEPA, Mensa Thompson, will be joining us with more on their position. But first, let's hear from some political parties who strongly oppose the Supreme Court's decision to reduce to 7 days the time frame within which an individual or party can file a presidential election petition. We start off with Vice Presidential candidate of the Progressive People's Party, Kofi Asamoah-Siao, who says the move is unconstitutional.
The provision in Article 64 for anybody to suggest any other procedure or timeline which is inconsistent with that constitutional provision, we have to do that through constitutional amendment, which actually has to go through a referendum. So the Supreme Court cannot, in my view, constitute themselves into Ghanaians and say that they have changed the 21 days period to 7 days. That would be completely unconstitutional. We are there to interpret and enforce the laws or the Constitution as is written by us, the people of Ghana. So that mandate will not include varying the constitutional provisions that we have it. So even if you come to Article 64(3), where the Supreme Court has power to make the rules, they don't make the rules by sitting in the Supreme Court. They make the rules through a constitutional instrument. And by practice and by constitutional provision, constitutional instrument, which the rules of court that Mr. Maleba was talking about, must be laid before Parliament. The Constitution says any citizen can file a petition. The Supreme Court says no. You have to be a presidential candidate. That is power you are taking from a citizen of Ghana. The Supreme Court doesn't have that power to take something away from us. And they're also saying that the 21 days must be 7 days. I hope at this stage there are proposals, there are recommendations, and if they are not, and they are going to insist on this, I will see it as an attempt to make it difficult for anybody to challenge the regulation. Well, definitely, as the discussion I just started, we need to, I think at this stage, the Secretary to the Judicial Council must, if you like, give Ghanaians further clarification on what the Justice's comment meant.
Well, member of the NDC legal team, Abraham Amaleba, agrees. He says the constitutional provision makes room for a 21-day preparation period and can only be reversed through a referendum.
If the Supreme Court intends to apply all these things that they have proposed in say 2021, if there's a dispute, then I think that it is too late now. I am thinking that these proposals are for the future, particularly the 64(3). That is doable, but you don't have a CI now. Parliament is not sitting now. You can't get the number of days that you want. And so I think that this is looking into the future, but not to apply it in the shortest possible time. If the Apex Court is now saying that you have to do that within 7 days, are they proposing to come with an amendment to the provision of the Constitution that says that you should do that in 21 days? I wasn't at the program, but I thought that that question should have been put out there for them to try to clarify. In the absence of any attempts to as it were, come out with a constitutional amendment, then it will be difficult for anybody to then say that you would have to bring your petition within 7 days. When Article 64 is clear, which says that you must do so within 21 days after the declaration of the results. So I still would want to find out how this can be done if there's no constitutional amendment. We have what is called the Court of Rules Committee. If the Court of Rules Committee sit down and look at all these processes, they are able to shorten the length of the trial. Then I agree, and I think that I'm in sync with them to have this done within 42 days. I think that is reasonable for me. I would convene a legal committee meeting, and then we'll look at the proposal and see what we can put together and present it to the Apex Court.
Well, chairperson of the Election Manual Review Committee, Justice Jones Duche, says the decision is legally binding.
The Supreme Court is proposing that should there be any dispute, it will not go beyond 42 days. And there are major significant changes in the law, in the sense that now if you are interested in pursuing or initiating an presidential election dispute, you must have been a candidate in that election. And you can only sue the one who has been declared as the winner by the EC and the EC. That's all. No political party will be allowed to join the suit. And we propose 30 timelines which will not go beyond 42 days. So these are significant material you find in the content of the manual.
All right, so we have Executive Director of ASEPA, Mensa Thompson, joining us in the studio. They're also kicking against these proposals by the Supreme Court. Thank you very much for your time, Mensa Thompson. But we hear a lot of assumptions. We hear a lot of recommendations, proposals, but then we are also told that this is binding. So what's your position on it? Is it binding, or these are just recommendations and proposals? Just clarify that for us.
Definitely not. These cannot be binding. We just rightly heard Justice Duche that this is a proposal, and we know that this country is not ruled by proposals. This country is ruled by laws. And like the previous speakers have argued, if you read Article 64(1), it clearly tells you what, or within the time frame within which, if you want to bring an action against any election results, you can. And the law says 21 days. And let me just read. It says, Article 64(1), the validity of the elections of the president may be challenged only by a citizen of Ghana who may present a petition for the purpose to the Supreme Court within 21 days after declaration of results. So 21 days after declaration of results. The Constitution is very clear. And if we read Chapter 1 of our Constitution, it talks about our Constitution and how, any enactment which is inconsistent with our Constitution, if we read Article 2, this Constitution shall be the supreme law of Ghana, and any law found to be inconsistent with any provision of this Constitution shall, to the extent of inconsistency, be void. So, the laws are very clear. What the Supreme Court is proposing is clearly inconsistent with Article 64. And rightly so, Article 64 is also an entrenched provision. And so you cannot just sit at the Supreme Court and issue manuals to override entrenched clauses. No, entrenched clauses must go through a constitutional referendum, which the people must vote to decide whether they want to amend it or not.
All right.
But I think there's a peculiar or something happening that we are not paying our attention to. You see, a few days ago, the Electoral Commission comes to tell us that they are going to declare results within 24 hours after polls have closed.
Right.
Then the Supreme Court, who, if anything happens, also comes to tell us that when polls are closed and elections are declared, that is after the 24 hours, you have 7 days to file a case or bring an action.
Right.
Then after you file the 7 days, they have 42 days to bring a judgment. Clearly something is wrong.
What is wrong?
These things cannot be happening in a vacuum. You see, you are going through a great crucial elections where over 17 million people are expected to vote, over about 38,000 polling stations, and you are saying that you are going to declare results in 24 hours. And I find it ridiculous, especially when the Electoral Commission themselves have just implemented a new system, which they haven't even piloted enough. They've brought whole new systems, which they haven't worked before. This whole set of commissions have not even conducted elections in this country before. And they are telling us they are going to declare elections within 24 hours. Even our Dr. Afari-John, the experienced Electoral Commission could not declare results within 24 hours. Then the Supreme Court also come to compound our problems. That they are going to You know, they are giving the parties within seven days. Mm-hmm. You have 38,000 polling stations, for Christ's sake. You know what it takes to gather evidence if you want to file a case.
Right.
And you are saying that you are giving parties just 7 days to file a case if they want to bring an action. I mean,
just for the purposes of benefit of those who might not know, how long generally does it take to file such cases?
You see, before you can file a case, you need evidence. You cannot file cases in a vacuum. You cannot go to court just because you feel like going to court. You need evidence to go to court. And when polls closes, you are now going to request for the pink sheets from your polling agents, going to get experts to audit the pink sheets, lawyers to look at the deficiencies in the pink sheets, and build up a case for the court.
So what you're saying is that it is very tasking. You cannot do that within 7 days.
Right. And the Supreme Court knows this. So and that is why the Constitution says 21 days.
But what do you make of the argument being put forward by some that the motive was for this is commendable? Because as you remember, the election petition, it dragged on for at least 8 months. People were tired. So perhaps they're seeking to, avoid that.
Yes, I totally agree with that expression. And we all agree that justice delayed is justice denied. We all want justice to be served in events that this election has to go to the Supreme Court or to a litigation process. But you cannot replace justice with expediency or with fluidity. No, that is not what we want. You want justice to be served. Now, if the Supreme Court will want to make a determination of a matter as quick as they can, it is very commendable. But the Supreme Court cannot sit at the Supreme Court in a vacuum and say they are going to use this X number of days. That is impossible.
All right, so what do you expect the Supreme Court to do, given the concerns raised by yourself, by the NDC, as well as the PPP?
First of all, they must withdraw that manual, because Chapter 1 of our Constitution says that any law that is inconsistent with any provisions of this Constitution is null and void. And once you have an entrenched provision making a clear statement or giving a proper guideline on how things should be done, the Supreme Court cannot replace that with their own manual. That is not that cannot be it. Then the most important point that we need to make is that why are we being rushed through all these things? Is it that we cannot take our time and go through these processes?
So the Supreme Court must withdraw this manual.
Yes, and within 42 days, what is the Supreme Court going to do? For example, the case is going on, lawyers are doing cross-examination. When they get to cross-examination, are you going to ask, tell the lawyers that, 42 days are up? So without a case in front of you, you cannot determine how long it's going to take you to make a determination of the matter.
Okay, Mensah Thompson, thank you so much for your time. He is Executive Director of ASEPA, and they are one of those kicking against the proposals by the Supreme Court to hear election petitions within 42 days.